Hello, everyone. My name is Kaman Shoilev, and I'm here to welcome you to our webinar on the subject of MiCA, the Markets in Crypto Assets webinar. We have already run such events earlier this year, and we're very happy to say that we have some more we would like to share with you. And today's is one of those. We will have an audience today of approximately 20 to 30 of you, I believe, and everyone seems to have to be strongly interested in this sector. So that's great news. We have on the speaker side today my colleagues Nevena, Maya, and Rostina, who goes by Ina. And we will be telling you about various aspects of MiCA. In comparison to the previous webinar which we ran, we will today focus a little bit more on questions of compliance and the various types of compliance that you may expect to see. We will also, through Nevena and her eyes and perspective, look at the implementation in Bulgaria of MiCA, an implementing piece of legislation for the specifics of the Bulgarian regulatory environment. And then I will give you my perspective, which is slightly different to that of my colleagues at the end, and that will concern international aspects of crypto, its regulation, but even more perhaps on the question of how in practice certain aspects of disputes in connection with crypto might operate. So without further ado, allow me to introduce firstly my colleague Nevena, who is a partner in our Sofia office, and she has a very varied practice covering both corporate and commercial matters, a wide range of those. And she has been advising a number of fintech projects, including in crypto, over the years. And she will start us off. So over to Nevena, please.
Hello, everyone, and thank you for joining our webinar. I'll explore how Bulgaria's new Crypto Asset Markets Act is shaping the future of crypto regulation in our country. Following the adoption of the European Union's Markets in Crypto Assets Regulation, Bulgaria has taken clear steps to align its national legislation with the new European framework. A significant development in this process was the introduction of the Crypto Asset Markets Act, which was approved by the Council of Ministers at the end of 2024. The Act was adopted by Parliament on the 20th of June this year and entered into force on the 8th of July 2025. The Act now serves as the main legal instrument for the implementation of MiCA in Bulgaria. Main objectives. The main objectives of the law are directly aligned with the goals of the regulation, namely to establish a secure and transparent environment for crypto assets in Bulgaria. A key focus of the regulation is to ensure a high level of consumer protection within the crypto asset market. One of the main mechanisms for achieving this is the introduction of a white paper for each crypto asset, and I will focus on the differences between issuers. Under the regulation, issuers must prepare the white paper before offering tokens to the public or seeking admission. The content and obligations vary by token type. General crypto assets, or so-called, or those that are not asset referenced or e-money tokens, require a white paper covering the issuer, the token, the project, the rights and obligations, risks, the underlying technology and environmental impact. It must include a non-technical summary, clear risk warning, management statement of accuracy, and explicitly states that the white paper has not been approved by any EU authority. Asset reference tokens require more extensive disclosures. To safeguard the value of asset reference tokens, issuers must establish and maintain reserves of assets. Additionally, they must maintain a certain level of their own funds, ensuring financial stability. This depth of information ensures transparency and helps investors evaluate the token thoroughly. The white paper must be submitted as part of a formal authorization process. When it comes to e-money tokens, which are fiat pledged and require a white paper similar to asset reference tokens, the requirement for reserve is not there. The paper must include redemption at par value, appropriate warnings, and the declaration from the management body. For all three types, white papers must be fair, clear, not misleading, machine readable, and published on the issuer's website before the offer or trading begins. In terms of regulatory supervision, the law designates the Financial Supervision Commission as the default competent authority responsible for the oversight of crypto asset service providers, as well as for issuers of asset reference tokens and other crypto assets. The Bulgarian National Bank, however, is responsible for supervising the issuers of electronic money tokens, consistent with its broader mandate concerning payment systems and monetary policy. Under MiCA, asset reference tokens may only be offered to the public or admitted to trading in the EU by issuers that are legal persons established in the Union and authorized by their home state. A limited exemption applies, such as where the total outstanding value of the asset reference tokens remains below €5 million over 12 months, or where the offer is made solely to qualified investors. The law assigns to the Commission a wide range of duties, including issuing, refusing, or revoking licenses for the public offering and trading of asset reference tokens. However, this procedure does not apply when the issuer is a credit institution. Credit institutions can publicly offer asset reference tokens, but only after their white paper has been approved by the Commission. They need to notify the Commission of the upcoming issuance of the token, and the relevant activity should be included within the scope of the license issued by the Bulgarian National Bank. Crypto asset service providers. The Commission also decides on the licensing of crypto asset service providers. Certain already licensed financial entities, such as credit institutions, central securities depositories, investment intermediaries, market operators, asset management companies, and alternative investment fund managers do not need to obtain a separate license to provide to provide a crypto asset services. Instead, they must submit a notification to the Commission and receive a confirmation that their operations comply with the applicable requirements. Besides the mandatory paperwork needed for licensing under the regulation, the law also sets out additional documents and checks to assess and confirm that the CASP's governance is properly in place. These requirements apply to the management team, shareholders, and ultimate beneficial owners. The law also introduces transitional provisions for entities already operating in Bulgaria as virtual asset service providers. These entities will be allowed to continue their operations until the 1st of July 2026. By that date, they will need to fully comply with the new regulatory standards. VASPs registered between the 30th of December 2024 and the date of entry into force of the law must apply for a MiCA license within 3 months of the law's entry into force. During this period, they must also ensure that their operations comply with the law and the regulation. Licensed crypto asset service providers must submit an application to the registry agency to record the activity within their business scope within 7 days of receiving the license or confirmation from the Commission. When it comes to consumer protection, the law provides that crypto asset holders, users of crypto asset services, and other interested parties, including consumer associations, can submit complaints to the Commission. Complaints can be submitted if they believe that offerers, applicants for trading admission, issuers of asset reference tokens, or crypto asset service providers have violated the regulation, the law, or related implementing acts. All complaints must be submitted in Bulgarian and in writing. To ensure compliance with the new legal framework, the Financial Supervision Commission is granted broad powers. Bulgarian law provides the national financial regulator with a wide range of powers to enforce compliance with the regulation when there is a breach or even a well-founded suspicion of non-compliance by crypto asset issuers, offerers, applicants, or service providers. The regulator may compel them to take specific corrective actions within a defined time frame. These powers extend not only to entities themselves, but also to individuals involved in their governance or operations. The aim is to prevent or limit the impact of violations and ensure that market participants uphold legal and regulatory standards related to crypto assets issuance, trading, and service provision. The regulator is further empowered to impose a broad range of measures, such as temporarily or permanently suspending crypto services, halting token offerings or trading, ordering amendments to white papers or marketing materials, and requiring public disclosures about breaches. In serious cases, the regulator may order the removal of key personnel, restrict certain business exposures, or revoke licenses. These measures are designed to protect retail users, safeguard market stability, and address misconduct proactively. The framework reflects a risk-based supervisory approach, enabling intervention even before harm has occurred. In cases of repeated breaches of EU or national crypto regulations, the Commission may propose that the Bulgarian National Bank revoke a credit institution's license. For example, the Bulgarian National Bank is required to notify the Commission of its decision without undue delay. The law establishes a tiered system of fines for breaches of the MiCA regulation, with penalties varying by severity, recurrence, and whether the offender is an individual or a legal entity. Fines for individuals range from a few hundred to several €100,000, while legal entities may face penalties of up to €15 million or 15% of annual turnover in serious or repeated cases. Thank you.
Thank you, Nevena. I didn't say that earlier, but of course we are open to any questions that you may have. And if you wish to ask us questions, you can either do so in the chat, or I believe you should be able to also signal, perhaps by raising your virtual hands, that you would like us to give the floor to you to ask your question. So feel free to do either of those things now, or perhaps towards the end of today's session, if you prefer. On that basis, let me see if there is anyone who has signaled. I don't believe there is. Not at the moment, and I believe there's nothing yet in the chat. So on that basis, we will move on to our colleague Radostina, who is a junior associate with us, and she will be talking about the implementation of MiCA and what are the key questions for CASPs. Actually, we did get a question just in time before we started with Ina, and that's how will the EU or local regulators protect MiCA regulated companies from unfair competition by crypto businesses registered outside the EU and the European Economic Area? Well, this is a question from Vasily. Vasily, I suppose a first line answer to that is that it's not necessarily a function that the regulation has allocated to the regulators. The MiCA regulation has allocated to regulators to engage in the protection of participants in the market per se. There are, of course, in the various EU member states, relevant laws that in some cases may provide that kind of protection against unfair competition, and this very much depends on a country by country basis. And so if we take your question to relate strictly to protection against unfair competition, then that would be the answer. It may well be that you also share that view, because I see that in fact you're proceeding to answer the question yourself along similar lines. Maya, would you have anything to add? Were you signaling that you want to add something to this? No. Okay. We will be very happy to chat further about this later on, but for now, let me move on to Ina.
Hello, everyone, and thank you for being with us today and for your interest in our webinar. I will now explain a little bit more about how MiCA creates a harmonized licensing regime for CASPs, and also about the new governance and capital requirements for CASPs, and also we will review the AMLR's impact on crypto space. So let me now start with the passporting regime under MiCA. MiCA creates a so-called passporting regime because it provides for a uniform license. For a company which aims to provide crypto services as a CASP, it is enough to apply for a license in only one member state, and after it obtains such a license, it can freely operate within the whole European Union. When it applies for a license, this company, or of course its management, shall be aware of the three classes under MiCA, which depend on the crypto services provided, because different crypto services fall within different categories, and thus the minimum capital is different for these companies. For example, if a company which aims to be a CASP wishes to provide operation of a trading platform, it shall be ready to have minimum capital of 150,000 euros. And it is important to mention that it is not important whether the company will cover all the crypto services in the respective class, but whether to observe in which class its activities fell within, because, for example, a company may not wish to provide all services under class 1, but, for example, if it wishes to provide exchange of crypto assets for funds, these fell within class 2, and thus this company shall be ready to have a significantly higher minimum capital amounting to 125,000 euros rather than 50,000. And also, when preparing for applying for a license, the companies shall be ready to provide certain kind of information which is related to the governance and conduct obligations of CASPs. And what are actually these governance and conduct obligations? As you can see on your screens, MiCA sets high standards for internal operations. And in practice, this means that each CASP shall implement strong internal controls in terms of mitigation, avoidance, and management of conflicts of interest. Also, MiCA aims to provide better investors protection, and it sets out rules for better communication between the CASP and its investors. Thus, the communication must be fair, clear, not misleading, and this means that it is important that the CASPs are upfront about the fees, about the project, the crypto assets, and the associated risks. What else are CASPs obliged to implement? It is important to mention the customer due diligence, the enhanced due diligence, their obligation for ongoing monitoring, for record keeping, and for reporting. Let me now give a little bit more background about each of them. When it comes to customer due diligence, it is important for each CASP to implement such controls that it can verify the identities of its clients, no matter whether it comes for natural persons or for entities. When the client is an entity, and the CASP shall check for its UBO. And also, there are some cases where enhanced due diligence is required. For example, for a client who is a publicly exposed person, and also when the client comes from a high-risk third country. In these cases, an enhanced due diligence is required. It is important to mention that CASPs shall continuously monitor transactions of their clients and to report for any suspicious activity to the competent authority. And also, when it comes to suspicious activity reporting, CASPs are not allowed to alert their clients when they have to disclose certain kind of information. Another important highlight is that CASPs must keep records of their customer due diligence and enhanced customer due diligence and other related documents for 5 years. Now let's see whether CASPs shall comply with the white paper requirement. White paper was mainly covered by my colleague Nevena. I will only add here that the requirement for white paper, for issuance of white paper, is generally directed toward the issuers of the crypto assets and not to the CASPs directly. A CASP will have an obligation for white paper only if it acts as an issuer as well. And also, CASPs must ensure that the compliant white paper exists prior to offering or listing a crypto asset. White paper must include certain kind of information. As my colleague mentioned, this information is mainly directed at better investors' protection because it requires from CASPs to reveal or from issuers to reveal information about the crypto assets, about the crypto project, and about the associated risk. So the potential investors are better aware of the crypto sector. And also it is important to say that a failure to comply with the white paper requirement when it's applicable to the CASP may result in liability. So, what are the obligations under the AMLRs? The latest AMLR was adopted on the 31st of May 2024, and it is the first unified AML rulebook across the EU. Here it is important to highlight that after its adoption, CASPs are obliged to comply not only with MiCA, but also with the whole AML regulations, not only with the last one, but also with previous ones, as they set out different rules. And it is important to mention that the latest AMLR does not leave space for different interpretations by separate member states, but rather a uniform approach. So I will tell you a little bit more about the travel rule. The latest AMLR contributes to the implementation of the travel rule, and I want to speak only about the core of this obligation, because my colleague Maya will discuss in details the travel rule in the next slides of our presentation. So the core of the travel rule is the obligation for the CASP to provide certain set of information about each transfer. This information may be related to the sender or to the beneficiary or to both of them. And according to the European AMLRs, the threshold, the standards which are set for the travel rule are even stricter than the FATF recommendations. So this means that the AMLRs are not only in line with the FATF recommendation 16, for example, but even go further. But you will find more about this in the next slides when our colleague speaks more about it. Let me now talk a little bit more about the enforcement and the penalties under MiCA and under the AMLR. Both MiCA and the AMLR have penalties provided for, and they are quite similar. The difference is when it comes to entities, because under MiCA, the fine can be up to 15 million euros or to 15% of the annual turnover of the company. And let me highlight that this fine is set only for severe breaches, such as market abuse, which is regarded as the greatest breach of the MiCA and also of the AML rules. And when it comes to the AMLR, the fine for entities can be up to 10 million euros or to 10% of the annual turnover. When we talk about natural persons, both MiCA and AMLR have the same sanction provided. A minimum maximum fine is capped at 700,000 euros, and it can raise up to 5 million euros. Let me mention that this cap of 700,000 euros is a minimum maximum. This means that each national authority, each national government can implement even a higher cap for the fine, but not less than 700,000 euros. Violations under MiCA include operating without required license or failing to disclose critical information. Also, another breach is inadequate governance and operational internal rules. Excuse me. And also under the AMLR, the breaches can include failure to perform due diligence or inadequate monitoring or failure to report suspicious activities. There can be additional consequences both under MiCA and under the AMLR. And these additional consequences may be asset freezing or managerial bans or also public disclosure of violations. And when we speak about public disclosure of violations, yes, they do not affect directly the assets of the company, of the crypto asset service provider, but such a disclosure may lead to significant reputational damage, and this may lead to significant losses as well for the company. When we talk about managerial bans, This practically means that certain individuals may be prevented from holding management positions or performing critical roles within an organization. So I think that these measures are also strict ones. Let me now conclude. And the aim of both MiCA and the AMLR is to contribute to sustainable integrity, better traceability, and transparency in the crypto sector. On the one hand, CASPs are subject to a uniform license, which practically means that there is better supervision of CASPs because they are part of one uniform system. And on the other hand, this system lets them operate freely within the whole European Union. Also, MiCA and AMLR provide for stricter obligations when it comes to better consumer protection because they oblige CASPs to provide clear and not misleading information. And this will enable investors to have better understanding of the crypto sector they are entering. Thank you all for your attention, and let me now give the word back to our managing partner, Mr. Kamen Schoyle.
Ina, once again, if there are any questions from the audience, we'll be, of course, very grateful, very happy to answer those. You will have all seen the chat, and that's been quite active, but we will be very happy to have even more opinions and participation in there. So thank you in advance. I hand over in the meantime, though, to Maya, who is the head of our anti-money laundering and white collar team, and she will discuss the interaction of a number of regulatory regimes in relation to MiCA and in relation to digital assets. Maya, over to you.
Thank you, Kamen. Good afternoon, everyone. Thank you for taking the time to join us today. I want to speak about the three regulation regimes: the market in crypto assets regulation, or the guidance on the ESMA for the market in crypto assets regulation. But let me explain, well, each of the regimes, Digital Operational Resilience Act, the Anti-Money Laundering Regulation, which my colleague Ina so eloquently explained in detail in her session, and the MiCA regulation interact and are interconnected. While each of these regimes focuses on a different dimension of oversight, whether behavioral, operational, or financial, they're deeply interconnected. Taken together, they form the backbone of the EU's new architecture for digital assets regulation. Let's begin with MiCA. Under Article 92 of MiCA, the European Securities and Markets Authorities was tasked with developing supervisory guidance on market abuse. On 29th of April 2025, ESMA published its final report and guidelines on supervisory practices for market abuse under MiCA. These guidelines introduce a two-tiered structure. One part is directed at national competent authorities, equipping them with tools to identify, mitigate, and prosecute market abuse in the crypto space. The other part is directed specifically at crypto asset service providers considered persons professionally arranging or executing transactions. At the supervisory level, ESMA is advocating a risk-based, proportionate approach. This means that regulators across the EU are expected to modernize their surveillance tools and focus effort on high-risk activities such as price volatility, cross-border flows, and social media manipulation. For CASPs that operate trading venues, over-the-counter desk, or handle significant retail flows, this marks a shift in compliance expectations. CASPs will likely be required to provide more detailed monitoring reports, demonstrate use of advanced trade surveillance systems, and prepare for cross-border supervisory inquiries involving multiple regulators and jurisdictions. CASPs who are arranging or executing transactions, whether directly through brokers or via programmatic trading systems, are now expected to implement real-time trade surveillance capable of detecting suspicious activity. This includes not only traditional markets abuse patterns, but also crypto-native forms of manipulation, such as minor front-running, spoofing across centralized and decentralized exchanges, wash trading, social media-driven pump and dump schemes, just to name a few. ESMA has also clarified the reporting obligations for suspicious activity. If surveillance systems detect behavior that could indicate market abuse, CASPs are required to file a suspicious transaction or order report. The threshold for reporting is reasonable suspicion, not conclusive evidence. Internal analysis supported by data is sufficient to trigger a report. In addition, CASPs must maintain internal protocols to handle such incidents. These protocols must include investigation procedures, escalation chains, and full audit trails from detection through to resolution. These guidelines are being integrated into national supervisory practices across the EU, with full implementation expected by the end of 2025. Accordingly, CASPs are expected to align their internal systems with these requirements, particularly in the areas of trade surveillances, suspicious transaction or order reporting, and market abuse scenario modeling. ESMA has also issued additional guidance under MiCA, including how to determine whether a given token qualifies as a crypto asset, a financial instrument, or electronic money, how to address reverse solicitation claims, and what suitability and disclosure standards apply when servicing retail clients. These elements are especially critical for CASPs who are operating cross-border or targeting retail investors within the EU. Turning now to DORA, the Digital Operational Resilience Act, which became fully applicable on 17th of January 2025. DORA marks a significant milestone in EU financial regulation. For the first time, CASPs are treated as regulated financial entities. For the purposes of operational risk management, under Article 2 of DORA, CASPs are subject to the same digital operational resilience standards as banks, insurers, and market operators. DORA itself is structured around 5 core pillars: Information and Communication Technology Risk Management, or ICT Risk Management for short, ICT-related incident reporting, digital operational resilience testing, management of ICT third-party risk, and coordinated oversight and supervisory convergence. Together, these pillars define how financial entities must prepare for, respond to, and recover from digital disruptions, whether caused by cyber attacks, internal system failures, or third-party service outages. Under the first pillar, the ICT risk management, each CASP must maintain a comprehensive framework for digital resilience. This includes governance structures extending to the management board with clearly assigned responsibilities. CASPs are required to maintain documented policies covering system monitoring, access control, data encryption, and change of management. Critically, each CASP must be able to demonstrate continuity of service in the face of severe internal or external disruptions. The second pillar concerns ICT-related incident reporting. This is among the most operationally demanding requirements of DORA. Any major incident, ranging from a prolonged outage to a successful cyber attack, must be classified using harmonized EU standards and reported within specific timeframes. In some cases, initial notification must occur within 4 hours. CASPs are thus required to implement real-time monitoring and automated escalation mechanisms to ensure timely and accurate reporting to national authorities. DORA also mandates advanced testing requirements, including thread-led penetration testing on critical systems at least one every 3 years. These are not routine scans, but realistic red team exercises designed to simulate advanced threats, including ransomware, insider threats, and state-sponsored attacks. Such testing must be conducted by qualified and independent testers, following methodologies prescribed by the European supervisory authorities, which includes ESMA, the European Banking Authority, and the European Insurance and Occupational Pension Authority. The fourth pillar addresses ICT third-party risk management. CASP must maintain an up-to-date registry of all ICT service providers and subcontractors. They are also required to conduct thorough risk assessment and include specific resilience obligation in contractual agreements. This should cover data protection, service availability, regulatory audit rights, and exit strategies. This is relevant for CASPs dependent on a cloud infrastructure, know your customer service provider, or blockchain node operators. Concentration risk, meaning excessive reliance on a single provider, will also be scrutinized by regulators. Finally, DORA strengthens coordinated supervisory engagement. CASPs are now expected to participate in cross-border regulatory inspections and contribute to threat intelligence sharing networks. The ECAs have aligned their inspection methodologies and issued legally binding technical standards. CASPs are required to submit the ICT vendor registry by the end of 2025 and should now be preparing for threat-led testing cycles and incident classification workflows in accordance with these standards. Let us now turn to the AMLR. This regulation brings the Financial Action Task Force travel rule with direct effect within the EU law for crypto assets transfers, as my colleague Ina already mentioned. Under the AMLR and the Transfer of Funds Regulation, crypto asset service providers are required to collect and verify complete originator and beneficiary information for all crypto asset transfers, irrespective of the amount. These regulatory frameworks align with the Financial Action Task Force's Recommendation 16, commonly known as the Travel Rule, which sets global standards for the traceability of funds and crypto asset transfers. While the FAT recommends applying this obligation to transfer above €1,000, the EU goes further by requiring CASPs to ensure this information accompanies every transfer with enhanced verification measures applied specifically to those exceeding €1,000. This obligation applies not only to transactions between two CASPs, but also to transfers involving CASP and a self-hosted wallet, as long as the CASP is either sending or receiving the asset. Where transactions involve politically exposed person, high-risk third countries, or other indicators of elevated money laundering or terrorist financing risk, CASP must implement enhanced due diligence. This includes risk-based transaction monitoring, strengthened identity verification, and the ability to delay, reject, or report the transaction if the required information is incomplete or raises suspicion. In practice, this means that onboarding, monitoring, and transaction processing systems must be capable of identifying counterparties, detecting anomalies, and flagging or blocking suspicious transfers. Furthermore, the infrastructure used to transmit personal data must fully comply with both the GDPR and technical guidelines issued by the European Banking Authority. Let us now step back and consider how these three regimes, MiCA, DORA, and the AMLR, fit together. Each addresses a different facet of regulatory risk. MiCA defines the rules of market conduct and sets out authorization conditions. The AMLR enforces financial transparency and ensures traceability of crypto asset flows. DORA secures the technological and operational foundation underpinning these services. However, these frameworks cannot be implemented in isolation. For example, the market surveillance tools implemented under MiCA must also comply with DORA's ICT resilience standards. Similarly, the customer due diligence processes under the AMLR must be integrated into systems governed by DORA's third-party outsourcing rules. Supervisory engagement will also become increasingly coordinated across conduct, anti-money laundering, and operational risk dimensions. Looking ahead to 2026, CASPs are advised to adopt a holistic, forward-looking approach. This includes conducting integrated MiCA and DORA gap analysis, enhancing market abuse surveillance, and embedding the travel rule compliance within transaction workflows. CASPs should also update white paper governance to include risk matrices, operational models, and ICT strategies. Maintaining an accurate vendor register, embedding resilient clauses in all critical ICT contracts, and scheduling the first thread-led penetration testing cycles will also be essential. Finally, incident classification and escalation procedure must be fully aligned with DORA's reporting timelines and taxonomies. As ESMA continues to advance supervisory convergence and as new frameworks such as the Directive on Administrative Cooperation and the Anti-Money Laundering Authority become operational, the EU is moving toward a single integrated compliance framework. This framework is grounded in transparency, resilience, and regulatory clarity. To summarize, MiCA determines what CASPs may do and how they must behave. The AMLR governs who CASPs are dealing with and how they manage financial integrity. DORA ensures that the systems underpinning crypto services are robust, secure, and resilient. For CASPs aiming for sustainable growth within the EU, these regulations are not hurdles, they represent the foundation of a trusted and regulated crypto ecosystem. Thank you very much. Now giving back the word to you, Kamen.
Thank you, Maya. Let's just see if there is anyone who has asked any question. I think there are no currently raised hands, but as before, we are very happy to see more of those. Now, I am going to slightly switch. Here we go. We have actually a question. Maya, I'm not sure if you can see the question in front of you, but it's whether the travel rule applies to Class 1 CASPs, and in particular in relation to order execution and order transmission.
Understood. Yes. In general, the travel rules applies for all transfers. As I already explains, it implements the FATF recommendation 16, but it doesn't discriminate on any additional requirements, for example, the minimum amount transferred. Yes, the travel rule does apply to Class 1 CASPs, including those providing order execution and transmission services, but with important, with one final, not final, but with the important limitations depending on the service structure and whether crypto assets transfer actually occur. if it's actually executed, it applies.
Okay, thank you, Maya. So as mentioned, we'll slightly switch focus for the last few minutes of this webinar. And I will next take you slightly to the more sort of practical or perhaps kind of determined through conflict results of regulation. And I'll also be talking to you about the landscape when it comes to both the UK, with a brief mention, as you will see, of the EU. The reason we have decided to focus on the UK is partly to have a common law system. Most, of course, European Union jurisdictions don't use the common law. They are civilian jurisdictions, including Bulgaria, by background, whereas very few, Ireland and Cyprus now remaining, in addition to formerly the UK as part of the EU, are common law. Nevertheless, the common law tends to be a little bit more adaptable, at least that's how it's usually seen. And so when digital assets first became popular, following the introduction, of course, initially of Bitcoin and subsequently of other well-known blockchains, disputes were often brought wherever at all possible to common law jurisdictions. Another reason why such common law jurisdictions became relevant was, of course, that often exchanges, for instance, were being set up in such jurisdictions, including the BVI, the Cayman Islands, the Seychelles and Hong Kong and Singapore, as well as occasionally in the UK. Those systems look, of course, to the UK and to England and Wales specifically for high level judgments, and from there, the English jurisdiction has been able to set the tone in relation to many of these issues. While our firm, of course, is a Bulgarian law firm, I am personally also qualified as an English lawyer, as a barrister, and several other colleagues are consultants and colleagues who work permanently for the firm are English qualified, and therefore we are in a position to provide you with advice and representation on English and other common law jurisdictions where appropriate and necessary. I will start by looking at what are the ways in which crypto assets can indeed interact with the judicial system. And these ways are multiple, as I hope I'll be able to persuade you. One such way is, of course, crucially as to who is the owner of certain digital assets that may be held in an exchange or in a decentralized finance setup. And there may be a single owner, or there may be a mixture within a single wallet of title belonging to multiple owners. So that's one interesting type of question. Another context in which disputes often arise, and therefore parties often need to go to court, is whether, as some of the parties might allege in a dispute, a fraud has been perpetrated on them. And indeed, the English courts, as well as other common law courts, have often dealt with such disputes where it's been alleged that there's been fraud. And in those cases, the questions turn on multiple issues that are both procedural and substantive in nature, but they might, for example, include questions about what is the extent of the fiduciary responsibility that may be owed by a party to some other party. One interesting question in that context, and we'll come back to it momentarily, is the question about how does it work in a decentralized context where you have simply a protocol, for example, and the intention of those setting up the protocol is that a lot of it will be self-executing through smart contracts, for instance, and that there will be no day-to-day involvement. And certainly no centralized management. Hence ideas such as Vitalik Buterin's idea of the decentralized autonomous organization, which of course became quite popular in the context of ICOs a few years ago, and is still popular with new projects in blockchain. There has been an English decision, which I will briefly tell you about in this context, which decides on the issue in a preliminary context. Another type of issue concerns intellectual property. Of course, NFTs have slightly fallen from their top fame, which they were at a few years ago, in the context of both collectibles and art. Nevertheless, there are still interesting questions around intellectual property and disputes relating to them. There's also questions about trademarks in the context of not just NFTs, but any other blockchain-related intellectual property names. And the question here is whether there's been a certain tendency for the language used in relation to the blockchain to become generic in nature, because of course, when you have something the more generic something is, the less likely it is to successfully attract and retain trademark protection. Most of the webinar today has been dealing with questions of regulation, and of course, therefore, there may be potentially disputes which are brought in regard to regulation. Europe hasn't had that experience, which, of course, blockchain developers and those launching tokens in the United States market had to deal with over the years, where the Securities and Exchange Commission was very aggressively enforcing through disputes the view that its then commissioners were taking. Of course, the position in the United States has changed under the current presidency of President Trump. And the SEC is now less likely, it is often thought, to be enforcing in this way. However, the European Union, as you will shortly hear from me, there hasn't been to date that much by way of EU-level disputes, but that may now be changing after the introduction of the regulatory regime that my colleagues have been telling you about. Yet another context is the context of insolvencies. Of course, whenever there is a corporate, or in those jurisdictions which allow for it, personal insolvency, there are questions as to both who do the assets belong to that may be part of the insolvency estate, and also how to perhaps return assets to that estate, which assets that appear to be in the estate are really not part of the estate and in fact belong to other persons. And of course, questions around valuation and how that might impact on both the ability of different creditors to play a role in the insolvency, and also the amount which they will be entitled to recoup in the event that assets exceed liabilities. In the context of family law disputes, questions around assets that may be held by spouses at the time of divorce may arise. And again, questions here about title, and also whether specific family law related arrangements as to title apply. So how do these questions how are these questions particularly related to the law of England and Wales? The English law has acknowledged in a series of judicial decisions that to a sufficient degree of certainty, it regards crypto assets, digital assets, as being capable of being owned, as being a species of property. There is legislation which is on its way to becoming reality, which will implement the same concept, and the courts will then be able to regard crypto assets, digital assets, as being a sui generis, a special kind of property. And that's expected to be adopted this year. Incidentally, we didn't speak about this today, but the UK has been also working on its own regulatory framework, which it published in May this year, and we may do an update webinar on that issue at some point. The other questions relating to this that the courts have dealt with, as mentioned, include questions about evidencing transactions. There is now a pretty well-established framework of the use of specialist companies that provide expert services, or their staff can provide expert services to the courts and act as witnesses in proceedings in relation to investigating the route of title to blockchain assets. And there are questions as to the control over private keys, which can then, of course, allow access to a wallet. And finally, perhaps worth mentioning that questions which might arise are as to the legal status of decentralized autonomous organizations and similar, and how they can be liable. Briefly dealing, I mentioned to you earlier that the EU hasn't really so far experienced a very large wave of cases regarding digital assets. There's been a decision now almost 10 years old in the Hedqvist case, where it was decided that the European Union rules in relation to VAT are such that digital assets, the cryptocurrencies, are not going to be capable, are not essentially subject to a standard rate of VAT. They're exempt. And that was important in so far as the services relating to them directly are considered the same as services that financial services that are otherwise performed by other financial institutions. There's also been a series of cases regarding trademarks and specifically distinctiveness, but that's been pretty much it. And so, as mentioned, one might expect that there may be more case law soon. However, turning now to questions about how one can make use of the English courts if there is a dispute relating to crypto assets. So, in general, jurisdiction in England depends. It is said to be a matter of personal jurisdiction. And so to establish jurisdiction in England, you need to serve, generally speaking, on a defendant or a respondent. And you can do so personally if you find them in the jurisdiction, or you can request the English courts to allow you service out. And to do so, they need to, generally speaking, unless there is an applicable international treaty, they need to find one of potentially 20 plus gateways that might be applicable to your situation. Once you have established that kind of a gateway, unless of course a treaty applies or the respondent or defendant is in the jurisdiction, you can sue in England And the English courts have been, as mentioned, quite happy, generally speaking, to provide remedies to parties that are victims of fraud. One such case concerned a individual, I believe of Thai origin, who sued somebody that she had paid, whom she had become acquainted with over Facebook. The person's initials were CS. There were, however, a number of other persons that were unknown that very likely had participated in this fraud, and there was strong evidence that this had been a case of fraud. So Ms. Bunyayam, the claimant in this case, applied for a summary judgment against these parties. And the parties fell into three categories. And you will see on the slide that in the Class A category of persons unknown, they were natural legal persons which had described themselves as being connected to the putative financial institution that she believed she had been dealing with, which had called itself ING-FX Group, or ING-FX itself. That was Class A. Those were those persons. The second group, however, were defined in a slightly different way. They were those persons who either operated or owned, for example, in the case of one of the wallets, wallet 8 ending in numbers 837B, that was hosted by Coinbase. And then the third person in this case was ING-FX Limited itself, which was a specific identifiable company. The point about this case was that it was possible to obtain a judgment against the second and the third group, but not in relation to the first one. And the reason why it wasn't possible to obtain it against the first one was that it was said that despite the issuance of an order requesting various parties and enabling disclosure of information, it had not been possible to identify those persons who had called themselves by these names or who had taken certain steps in the fraud. They simply couldn't be identified. They were very much like the hit and run drivers in a traffic accident where such a driver may be driving a car with a certain number plate, but it had not been in fact possible to identify them, and it didn't look like it would be possible to identify them. So the point about this judgment was that yes, it was possible to obtain final relief, so an order for payment from the category B, Class B, and from the third category, but not from the first one. It had, however, been possible to obtain interim relief, so freezing injunctions, including a proprietary order against the others. And very briefly to finish off, there is I mentioned already the tulip trading case. This was a case in the Court of Appeal in England and Wales involving the saga against involving the individual who had said that they were the inventor of Bitcoin, Satoshi Nakamoto. This was a Australian person by name of Dr. Craig Wright, and on the other side of the case, there was a group of developers that were being sued by a company associated, Tulip Trading, which was associated with Mr. Wright. The developers, including Van der Laan, claimed that they had no fiduciary duties, but the Court of Appeal found that at least a preliminary level of inquiry, it could see how fiduciary duties were owed by software developers. The court acknowledged that this was a very new type of duty. Previously, such fiduciary duties had been said to be owed by specified other categories, such as, for example, lawyers, trustees, and others. But in some cases, software developers could owe such duties, and the software developers in a blockchain context of decentralized protocols, for example, in the context of DeFi pools or DAOs, could be such fiduciaries, and then they would owe potentially there would be proprietary and personal remedies potentially available against them. And the final case mentioned here, Joseph Keen Singh Law versus Huobi. Huobi, of course, is a crypto exchange. The order that was given here involved obligating the exchange, Huobi, to transfer crypto assets that had been held overseas to the English jurisdiction, so that in the event that there was a further order, there had been a default judgment against the persons unknown, and so that if there was a further order to get their assets that were said to belong to them and transfer them to the claimants, that order could be performed. As you can see from this, there's quite a bit of depth of case law already in England and Wales, and also in other common law jurisdictions. There are a number of very interesting points raised. Broadly speaking, the English courts are in favor of assisting parties involved in such disputes, and they're very flexible. So you can expect more cases to arise as a result of disputes in the EU for sure, but you can also expect the English case law to continue developing further. Apologies, I've taken more time than I expected to. Are there any questions in relation to what I have said? I believe not. If you don't have any other questions for my colleagues either, then this will conclude our webinar for today. You're very welcome to ask us any questions via our website contact form and via the email addresses from which you know about us. We have an office in Central Sofia, and we can also meet up with you in London. Very grateful for your attendance and look forward to speaking to all of you very soon again. Thank you. Bye-bye.